Morning everyone, my name is Katie Glendinning and I'm a partner in the employment team at Clarks Legal, and we're here today to discuss aspects of the Employment Rights Act, which is of course one of the most significant pieces of employment legislation ever, and certainly for more than a generation. It's an extremely large act of legislation, so you'll be pleased to hear that we're not covering it all in this hour, and instead we've chosen to focus on some of what we think are the most imminent and hottest topics at the moment that we're getting questions from our clients and prospects about. Therefore, we've chosen these topics to chat through to you because we thought that they were most likely to impact on you as HR professionals and business leaders alike. So these are the topics we're going to try and get through with you this morning. And so we've picked 5 key areas rather than doing the whole act in one go, but of course you may do future webinars on other issues in the future. And so the aim today is to cover off those, give you an overview of what the law says, and then give you some practical tips of how to implement that in practice and make sure that you are ready for the changes coming in. And then hopefully you'll leave the session today feeling more confident to put that into practice within your business. And so straight on with the first topic, I'll hand on to Lucy, who's a senior solicitor in the team, and then we'll go from there.
Okay, so hi everyone. So we're going to start off with unfair dismissal, which I think everyone agrees is probably the one that people are most concerned about, the change that's coming in. It's certainly the one that's had quite a lot of press attention. So let's get started with a quick overview of what the changes are. So there's sort of 2 key changes. The first is the removal of the 2-year qualifying period, and that's going down to 6 months. You'll probably all remember when they first announced the Employment Rights Act, the intention was to remove it entirely, and then that was negotiated up to 6 months. So you will still have that 6-month period, but it will no longer be 2 years. And they're also removing the compensatory cap. So this is for unfair dismissal claims and unfair dismissal claims only. Currently, there's a cap in place, which is 1 year's salary, or I think it's just about £125,000 at the moment. That's going to be removed entirely, and we'll talk a little bit about what that means in practice in a moment. These changes are coming into force on the 1st of January 2027, but they are going to be backwards looking. So what that means is that from the 1st of July this year, which is only a few weeks away now, anyone who is employed from that point onwards will have this 6-month qualifying period for unfair dismissal claims. The only other change that I just wanted to flag as well, because I think it's quite important here, is that in October 2026, they are going to be changing the time limit to bring claims from 3 months to 6 months. And the reason I'm flagging that is because we think the knock-on effect of this unfair dismissal change is going to be an increase to employment tribunal claims. There's going to be more and more people who have the qualifying service to be able to bring those claims. I'm sure most of you will already be aware, but the employment tribunal is currently overwhelmed, to put it nicely, I think. There is not enough judicial resources, there's not enough judges, there's not enough funding, and the claims are escalating and escalating. So the last quarterly report they produced said that there was a 47% increase in caseload for the tribunal compared to this time last year. So that's a huge increase. And the tribunal simply isn't equipped to deal with that level of increase. So with everyone having earlier rights to bring unfair dismissal claims, a longer time period to consider whether to bring those claims, and of course having AI on their shoulder to help them draft those claims, what we're going to see is an increase in the amount of claims that are brought and the complexity of those claims. And it's something that people really need to be aware of when you're considering mitigating those risks, because I think it's going to have quite a big impact. So a few tips for you, because I appreciate that's probably quite intimidating. Firstly, is to update your contracts. You've got a small window before the 1st of July, and obviously you can keep updating those contracts for any new starters between then and the 1st of January. And particularly, there's 2 areas that we're recommending people focus on. So firstly is probation periods, making sure firstly that you have a probation clause in your contracts, and that is representative of the fact that this 6-month window is going to be your only window to dismiss in. Well, you could still dismiss, obviously, but without the full process. We are recommending, for most employers, a 4-month probation period, with an option to extend that by a month. So that still gives you a little bit of wiggle room if those time periods slip slightly. If someone's on sick leave, for example, or on holiday, gives you a bit of a window still to address any issues. And the other change that we're really recommending is to make sure you review your pylon clauses. So for a start, so that's pay in lieu of notice. Make sure you have those clauses in your contract. Make sure you have the ability to pay in lieu if you need to, and make sure that's if you want it to be basic only. Obviously, assess your company needs and what you want that to be, but make sure you have that possibility, so you're not caught in the trap where someone has to work their notice and it pushes them over that 6-month period. We're also really recommending that employers review their probation processes. So that's looking at having regular reviews, weekly check-ins, and then monthly, more formal reviews of what's going well and what's not going well. You're going to have this small window to really assess your employees, and it's going to be difficult for both parties because employees are really going to have to prove themselves in that window, and we're expecting employers to be a little more harsh about what they will and won't tolerate in that opening period, because obviously it is much shorter than the usual 2 years of sort of flex that we had previously. And tied to that, it's really important that you're keeping accurate records. This has always been important, but I think that need is much greater, because if it gets to the point where you are looking at dismissing someone at, say, 8-9 months, we're really going to need those good records of the probation period you've been through, any issues that have arisen. Those records are going to be even more important than they ever were before. We're also recommending that you review your recruitment and onboarding processes. So make sure you are looking at your recruitment processes. How many interviews do you have? What kind of interviews? Do you have a culture fit interview, for example? Because of course, it's not all necessarily about skills. Do they actually fit in the team? We know a few employers are looking at doing personality testing, personality screening, to make sure that they're a good fit, that they respond to stresses in the way that fits well with the culture of the company. So that might be something to consider if you haven't already. And then looking at your onboarding processes. What do those first 2 weeks for those new employees look like? Are they welcomed into the team? Are they do you do the appropriate training to go through your harassment training, your risk training, and are they properly integrated into the team and shown how to do the work, given the best chance of success? And then finally, and I think this is something that we're going to come back to repeatedly through this webinar, is training for management. So it's all well and good to have all these processes in line, good policy guidance, HR's got it worked out exactly. But that doesn't really mean very much if it isn't then cascaded down to your management. They're probably the people who are going to be doing the recruitment in a lot of cases. They're certainly going to be the people doing the probation reviews, keeping the records of what's gone well, what needs to be improved. And they really do need to be trained on these risks. They need to understand exactly what the requirements are going forward. And then the last thing I just wanted to touch on to do with the compensatory cap is the risk for senior leadership exits. So the compensatory cap, the removal of that doesn't affect or won't affect a lot of employees, because a lot of employees will probably have been under that cap anyway. But it is going to be particularly impactful if you're trying to exit someone in the senior position. And we're expecting to see some much higher value settlements needed to be able to exit those people, because the value of claims is going to rise generally. So that's something to take into consideration when you're considering any kind of exits for those people.
Oh, thanks, Lucy. So I'm going to talk about the next topic, so fire and rehire, which is always in the news whenever it happens. And so the government were keen to factor this into the Employment Rights Act and make sure that they were seen to be preventing what they see as unhelpful and draconian practices. So we'll go through the changes first. I think it's important to say at the start that while fire and rehire will be severely restricted, the actual final act is much softer than the initial announcement that were made by the government, which were essentially they would be banned outright. That isn't what we've ended up with, which I think is sensible, because there are some legitimate reasons that you might want to look at fire and rehire, and I don't think any business has ever done that lightly anyway. And so this change is coming into effect from January as well. So the same as the unfair dismissal. And yes, in principle, fire and rehire will become more restricted than it is now. So it won't be an option in as many cases as it currently has been. They're introducing 3 new automatically unfair dismissals. So at the moment, one of the obvious examples we have quite often is a whistleblowing dismissal that is automatically unfair. What that means in law is that you don't have the chance to defend it. So if it's found to have happened and it's found to be a dismissal for that reason, there's no defence you can put forward to avoid compensation being awarded, essentially. So it's really important that you avoid these, if at all possible, because they are potentially problematic and costly. The first one is the obvious fire and rehire situation. So where you use a fire and rehire process to dismiss employees on their current terms and re-employ them on varied terms because they refuse to agree voluntarily to those changes. That has been limited to what is defined in the legislation as restricted variations, and I'll take you through those shortly. But I think where we've got to is actually they would always have been super high risk, and we would always have been advising that it would be unwise to use a dismissal and re-engagement process for these variations without very, very good reason. The second one is basically where you use it to employ someone else, so fire and replace, where you use it to employ someone else into the same role on varied and generally less favourable terms, although that isn't a requirement under the Act. It can be any terms that are different for the same role. And so that is to address some situations that have applied historically, where there was a famous case involving pilots, for example, where they got rid of lots of pilots and then replaced them. And of course, the P&O case is that scenario too, where they replaced the P&O people with other people who are happy to take less valuable terms. And then the third option, and the automatically unfair dismissal, is where you try and outsource, essentially. So you say, we're not going to employ directly anymore, that's too costly. We're going to instead replace those employees with self-employed contractors or workers to carry out the same role or a very, very similar role. And again, that's because the whole purpose of the Act is to protect employment and ongoing, decent, safe employment, however that's perceived by the drafters of the legislation. There are really limited exceptions. So there is a financial distress exception that I think is going to be interpreted really narrowly in the same way as it currently is around the collective consultation rules. So in essence, it needs to be essentially impossible for you to continue to operate without making these changes, is where we think it's going to end up. To be clear, that doesn't mean you can dismiss and there's no risk. All that does is mean that it won't be an automatically unfair dismissal. It will revert to a normal unfair dismissal, which means that you then have the ability to point to one of the 5 potentially fair reasons and show you followed a fair process within the constraints of the financial difficulties you were in. We don't know the scope of that exception yet. We won't know how that plays out in the courts until we've got some case law on it. A change that's already happened is the protective award has doubled, so it's now 180 days rather than 90 days, and that's with effect from April. So that was one of the changes that came in then, and that's relevant because if you are doing a fire and rehire, dismissal and re-engagement process, and you've got 20 or more employees impacted by that, that is deemed to be a redundancy situation for the purposes of the legislation, which therefore requires you to collectively consult as if it were a redundancy. Even if you get through all of those loopholes and you are able to show that you are varying not one of the restricted variations and you're not doing one of the automatically unfair scenarios, you do still need to show that you're following a fair dismissal process. And the best source of advice on that is the statutory code of practice, which still applies and has statutory effect. So you will be penalised at tribunal if you don't follow it and can't show that you took reasonable steps to follow it. And that will require you to look at being able to account for and show a valid business case for the change, that you followed or made attempts to follow a fair and reasonable collective consultation process where applicable. And it also looks at incentives that have been offered to try and get staff to agree rather than it being seen as undue pressure. And then briefly, and you'll get the slides, so I won't take you through them all word by word, but this is the restricted variations. These are going to be the changes that you cannot make anymore without the staff agreeing. So I think what you'll end up with then is negotiations around how you get staff on board if they're deemed as business critical. And so pay and performance, obviously, it's the government wants to limit you being able to reduce someone's pay and forcing them to accept that reduced pay. And we would always have said, that's really risky, don't do that without agreement. It's quite broadly defined though, so it is essentially any remuneration. It will cover commission schemes and things like that at the moment. It's any sum payable in connection with employment. So there's been discussion around whether that would include expenses and how those would be measured, although the government have given themselves the ability to carve out certain types of pay, and we expect that to include expenses because I don't know how that would be measured otherwise. It also includes any commission where it's based on performance. And my flag there is lots of commission schemes will be contractual. And so I think that the key there would be making sure that they're for a set duration. So normally 1 financial year, and then you'll have the ability to vary the scope of them every year rather than you being stuck with the commission scheme that you entered into when they first started employment. And then the last one under pay is pension and pension schemes. And that would always have been super high risk anyway, because you have the separate pensions regulations that you need to comply with there. And then working time off, it's any increase or decrease to hours, variation in the timing of shifts. So we're looking at whether or not we can get around that by being less prescribed on the shift patterns that are being worked. A variation clause will become a restricted variation. So if you haven't got a variation clause in your contract, you need to make sure you get it in before the 1st of January, because you won't be able to include one thereafter. And then the really broad one, which I think is worrying me most, and it's where I'm starting to look at kind of future-proofing contracts, is the government can expand that list whatever they want. So at the moment, those are the restricted variations, because I think that's what they thought they wouldn't get pushed back on at the Lords, that they have given themselves to produce secondary legislation in due course, which expands that list out to whatever they want it to. And then quick tips, I've touched on it already. A contract review is super important. So you have between now and the 1st of January, before this change comes into effect, to properly review your contracts, work out if they're still working for you, work out what you may want to change in the future and whether or not that would be caught by the restricted variations. You also need to have a business assessment, I think, on what we think may become a restricted variation and try and get in ahead of that as well. And so the obvious things around there might be looking at place of work, for example. I think that might be something they target in the future, given that it's designed to increase the employees' rights. And so it's aimed at giving yourselves as much flexibility as possible, because if you have appropriate flexibility within those clauses, the argument is that you're not varying the contract, you're applying the contractual terms that you already have a right to apply. Obviously, there's always a reasonable test with how much that works, but we think that's the best strategy around things like that. And we're dealing with things like hours rather than saying you will work from this hour to this hour every day. If you know they're on a shift pattern, which is particularly important for some sectors like retail, for example, you can word that more vaguely to say that you will work this number of shifts on average over a 4-week period or over a month period. And then you've got the flexibility to then give them shift patterns with a rota rather than being stuck rigidly with whatever's stated in the contract. The other thing to really bear in mind is discretionary versus an entitlement. The restricted variations apply to entitlements only. And so it's worth looking at your benefits, your commission schemes, your bonuses to make sure that wherever possible, they are not a contractual entitlement and therefore won't fall within the scope of the variation limitations. And that's particularly true around those things like some companies will offer enhanced redundancy, make sure like sick pay, if you've got any company sick pay, this will limit your ability to change any of that if it's deemed to be a contractual payment in due course. And then the only other thing is that if you are triggered to do collective consultation, if you're looking at harmonising terms or doing a general review, rather than having to run elections every time you do that, it may be that you look at setting up a general employee forum that are already assigned to be reps in those processes, rather than it just makes the process shorter if you do end up having to do that. I think that was all I was going to say on that. Move on to something a bit lighter. Maybe.
So we're going to touch on family-friendly rights and flexible working. There are a number of different changes that are coming in as part of the Employment Rights Act. So we're going to touch on a few of those, some of which have already come in, some of them are sort of in due course. And starting with paternity and parental leave. Now, this change is already in force. This was from April 2026. So hopefully most of you will already be aware of the change, but we just thought we'd flag it because if you're not already aware and you're looking at reviewing your policies and contracts, this is definitely one to have on your radar. So from April 2026, both paternity leave and parental leave are day one rights for employees. And then there was another piece of legislation, so technically this isn't in the ERA, but it's relevant here, that was sort of slipped in April 2026 as well. And I think quite a few people missed it because of the focus on the ERA. But this is this bereaved partners paternity leave, bit of a mouthful. And what it is if a primary parent passes away within the first year of the child's birth or placement, and primary parent here is the child's mother or the primary adopter, the other parent is entitled to up to 52 weeks unpaid statutory leave. It's a day one right, and as I say, it is unpaid, although I believe there are discussions to bring in a paid entitlement. Whether that comes in or not, sort of wait and see situation. It's up to 52 weeks leave, and it needs to be taken within 52 weeks of the death of the other parent. The notice requirements depend on when the leave is requested to be taken. So if it's in the first 8 weeks from the death, you can give notice on the day of you take leave, and it can be done just by a phone call. But if it's after 8 weeks, you need to give a week's notice, and it has to be in writing. Excuse me. So what we're suggesting is that you have a look at your policies. This is a new type of leave, so we'll probably need a new policy. But you might already have compassionate leave that this will sort of integrate with. So certainly have a look at your policies and see if you can sort of fit those together. So the next one, Katie, do you want to?
Yes, of course. So flexible working. Lucy's sorting herself out. So this is also coming in 2027. We don't have a set date for this yet. Sometime in 2027. I think it's likely to be April or October, because that's generally when legislative changes happen for employment law. So they normally tie it in with the new financial year in April. So I think this is quite a small change. So you're going from being able, the list of reasons that you're able to refuse a flexible working request is remaining the same. So you have the 8 statutory reasons. And what's changing is that when you reject a flexible working request for one of those reasons, that rejection must now be reasonable. And I think most employers would have been working on the basis that they couldn't unreasonably reject a flexible working request anyway, especially because of the separate legislation around the flexible working process and the right to challenge that if they didn't think that one of the reasons was used validly. So I think in practice, I'm hoping it's going to be a fairly small change, but what it does mean, going back to what Lucy was saying at the start for unfair dismissal, is your record keeping is going to be more important than ever. I know in practice I've advised, and we've had difficult discussions with an HR team where we've been saying they don't really understand why the manager can't accommodate it, and nor do we, but the manager is adamant that they can't. I think this is where you'll have to push back a bit more as the HR professional and say, actually, we need to show this is reasonable. I need more from you. I want to help you. If you're saying you can't accommodate it, that's fine. But you need to tell me why, and it needs to fit within one of these reasons. And you normally can slot it into one. You might just need the manager to give you a little bit more detail on the specifics, rather than just saying, no, we can't do part-time in our team, which I know does happen sometimes. And then there'll be a defined consultation process that needs to be followed. I don't think that's going to be a dramatic departure from what you already have with the set timeframes. Most businesses will offer an appeal anyway, even though strictly speaking, that's not clear in the legislation if that's needed. And you'll need to provide this written explanation. And I don't know any businesses that don't do that already. I'd certainly already have been encouraging them to do so. The aim, obviously, is to make flexible working more normal, whatever that means, whether or not that's compressed hours, reduced days, working pattern, place of work, all of that sort of stuff. And so we'll see how that pans out in practice, because I think businesses were already on that journey anyway. In terms of top tips, start looking at what your flexible working patterns are and where your tricky areas will be. It's important to remember that you look at flexible working requests in the order they're submitted. So it is okay to say no to a later flexible working request, even if they're asking for exactly the same thing as someone has earlier that you've accepted, because you are allowed to look at your team as it is when determining the impact of a new flexible working request on it, which I think some businesses can get a bit nervous about. It's like, well, we've got that person working this shift pattern, it's difficult for us to say no. But if that person working that shift pattern means it would be much more tricky for you to accommodate someone else working it, that is relevant when looking at rejection. Obviously, you should look at your employee satisfaction and engagement and make sure that the hours and the package is working for them. And evidence is going to become really important, especially with COVID and the hangover from COVID, with obviously people working from home a lot more. If you have a manager that is saying home working does not work for my team, I need collaboration, which is what is always cited. You need to push back and see what that means as the HR professional. What does that mean? Why can't they collaborate remotely? We've got all of this video technology, we've got Teams and all the other stuff that means they should be able to function as part of a team. And the employee is always going to say now, I've been working at home, no issues have been raised in my performance, there's been no conduct issues for 5, 6 years. So you tell me why I can't make that a permanent one. And we're starting to see those flexible working requests filter through as businesses are trying to move people back into the office gradually. So we expect that to continue. And so it's just making clear that where things aren't working, absolutely document that so that you're ready to push back when you do get those requests if it is an issue, and make sure the managers know that they should be raising that. So I think when you get the employee saying, well, no one's told me there's been any performance issues for 5 years, it becomes very tricky for the manager to then say in response to a flexible working request, actually, there's been loads of issues, I just haven't mentioned them to you. And then there's a risk of a retaliation argument as well. Discrimination has always been an issue with flexible working. So, of course, it is likely in some cases that the reason that they're requesting flexible working is to accommodate childcare, elderly care, because they've got a medical condition that makes it harder for them to be in full time or need some adjustments around their working pattern or working hours. Quite often they'll want to avoid rush hour if they struggle to sit down for long times, for example. And so that needs to be factored in as well. That's not actually directly relevant to your flexible working process, but it could lead to an indirect discrimination claim, or if it's a disability case, if reasonable adjustments or a Section 15 discrimination arising from. So it's something else to bear in mind. And from a sex discrimination perspective, the tribunal still have this assumption based on the data that women bear the responsibility for childcare. And I know that that's not all women and it's not all men, but the data backs up the fact that there is an indirect discrimination argument where a flexible working request won't be supported. They can argue that substantial disadvantage, that's not for them to prove, they can rely on the data. And then, yeah, again, going back to what we said before, management training, make sure that they are aware of what they can say no for, make sure they know the statutory reasons and that they start thinking about those. The other thing you'll need to factor in is once we know what the new consultation process is going to consist of, make sure they're aware of the time limits, because I know sometimes managers get caught out with that at the moment where the appeal process is actually part of the prescribed time limit unless you agree an extension, and that can sometimes lead to technical breaches even when you've done everything else right. And this one is me. So bereavement leave, another 2027 one. So this is one that we're still waiting for some of the details for because it's one of the ones that's further away. It's going to be another day one right to unpaid bereavement leave. I don't know if that's likely to end up being statutory. I think it was talked about as being the statutory pay initially, and then it's been confirmed as unpaid currently. The important thing here is it's being extended to just parents. At the moment, there is parental bereavement leave as a statutory leave. This is going to go beyond that. It's going to be 1 week for immediate family and dependents, and they get to use that within 56 days of the death. Helpfully, we don't yet currently have any definition of what a dependent means for the purposes of this legislation. It's also important to note that it's going to be extended to cover miscarriages before 24 weeks. At the moment, only after 24 weeks is covered by the other family-friendly legislation. And that ties in with the changes that have happened already around being able to get certificates to show that. And also any unsuccessful IVF cycle. So where there has been a cycle that hasn't worked, you would get the same leave as everyone else under this framework. Again, I think this is probably catching up with what most businesses do already. I don't think a 1 week unpaid leave is something that many businesses would refuse in this situation. So it shouldn't have a huge impact on the ground, but it is something for managers to be aware of, that it is a statutory right. So it's not something you can turn down if it's inconvenient. And we wait to see what the rules are, because sometimes there's a right to postpone if there's a business need, but I don't think that would be practical in this scenario anyway. It's the same kind of top tips with the other family-friendly rights. So please do review your policies, make sure they're updated, ready to go. And it may be that you wait and do those a little bit later once you've got the outcomes of the consultations on these areas and know exactly what the detail is going to be, rather than guessing at this stage and then having to do it again. And check what you already offer. So lots of businesses will already go beyond this on a discretionary basis or a contractual basis. So if you're already offering a week's paid bereavement leave, then of course you can just wrap that up and say that you'll always comply with the statutory obligations as well. And then, as we've said for everything else, make sure managers are aware that this is a statutory right, and so that they know they don't do anything inadvertent and get it wrong, especially because of the expanded definition. So there's some quite nuanced bits there about what a dependent is and what immediate family will count as. So they might capture people that perhaps you wouldn't automatically assume that it would. And then pregnant women and new mothers. So this, again, is a really unclear change at the moment, and one that is potentially not an issue at all, or one that could potentially be really problematic depending on where we end up. This is another 2027 state change, which means at the moment we haven't got any of the detail. Currently, of course, mothers and pregnant women are protected in a redundancy situation over and above those that aren't in that protected period. It doesn't mean that you cannot make them redundant. It means that they get priority to suitable alternative roles. This is an extension of that. So the proposal is that it will extend beyond redundancy to the other potentially fair reasons. And I reread the fact sheet on this today to see if we had any clarity at all, and we don't. So all it says is it will be some or all of the other potentially fair reasons it will extend to. My view is it would be completely unreasonable to not allow you to dismiss a new mother for gross misconduct. So I cannot see them including conduct within this, but they may look at, actually, you need to be much longer with your capability process, expected to be more patient with your absence levels and those sorts of stuff. So we'll see where we get to. And then obviously they wouldn't be able to stop you dismissing if the contract was illegal either. So I think we're limited really in which potentially fair reasons they can target it for. It's going to be the same protected period as applies for redundancy currently. So essentially the 6 months post returns at 18 months from birth. And there will be some limited exceptions, but those are currently TBC. And then top tips are tricky at the moment until we know the scope of it. So again, I think once we know where we're going to end up, absolutely look at your policies, look at issuing some guidance for managers on how they deal with that, because it will, with the redundancy, I think we've already seen it does fundamentally change how you can manage those processes. And it can be really tricky in a redundancy situation where you've got a really strong pool of candidates and you have to give it to someone even if they weren't the best candidate, and that can cause issues with the rest of the team and the wider business if it doesn't feel fair. Obviously though, that's not me saying there isn't a good reason for it. I'm saying it's just working out how you manage it and the comms around that. And then, as with everything, make sure your managers know what their obligations are. There's nothing worse than you end up in a situation where the managers follow the process that they would normally follow without any awareness that the person they're having the process with is protected, and then you have to undo all of that. And so that was all I was going to say on that.
So the last one is equality reporting. Now, this isn't going to apply to everyone on this call, probably. It only applies to large employers, so 250 plus employees. And it is a requirement to publish gender pay gap and menopause action plans. Now, currently, this is voluntary, but from April 2027, it's going to be mandatory. And I think it sounds quite intimidating, but in practice, I don't actually think it's going to be as difficult and intimidating as it might seem. So the government already has the website set up, which you can go and have a look at for how to publish an action plan, what they're expecting from you. And it boils down to there are 18 actions that they have come up with that have guidance for each one and examples of how they work in practice and why they think they're appropriate actions. And they're asking employers to commit to two, one for your gender pay gap and one for menopause. Now, the actions are things like having inclusive job adverts, putting your flexible working allowances on your job adverts, having menopause support groups, things like that. And I think a lot of employers are probably already doing these actions anyway. So it's just a matter of committing to two of those. What you will need to do is have a responsible person to sort of sign off that you are aiming for those, that the information you're giving is truthful. And that needs to be someone from senior leadership. I think the guidance says that it needs to be a director or officer. So you really do, it's not just for HR to work out what the actions are going to be and come up with this plan. You need sign off from someone in senior leadership, which I think the important tip here is that you really do need to get people on board with whatever your action plan is. There needs to be a bit of buy-in across the business on what you're aiming for and how you're going to get there. And then you really need to document what's happening. So the idea is that you're going to have these plans for 1 year, and then the following year you're going to report back on what's gone well, what's changed. As of yet, there isn't going to be any kind of penalty system for not improving on those action plans, not sticking to what you say you're going to do. And I haven't seen anything that suggests that that's going to be brought in. I think the scope is relatively limited, but obviously they are published. So any of your employees can look at these action plans and say, well, you say you're doing this, but there's no evidence that you're actually doing that in practice. So I think from that perspective, from sort of an employee satisfaction side, you really do want to say what you say you're going to do. And we think something that's going to be really important here is accurate data collection and record keeping of what you've done. So I would really recommend that you review how you collect data on gender pay gap, for example, and menopause, how useful that data is, whether it's actually accurate and relevant, and then maybe have a look into other ways of collecting data. Perhaps employee surveys would be quite a good way to get that data. And that probably goes for some of these other areas as well. A lot of the Employment Rights Act changes, I think, come down to employee satisfaction and trying to reduce risk by making sure that everyone is happy where they are and properly supported. And perhaps some employee engagement surveys is a good way to sort of start that ball rolling. So moving on to harassment. Now, this is a big focus in the Employment Rights Act. And I think some of the changes coming in are going to be ones that are a little bit more intimidating for some sectors specifically. So we're going to start with going through what the changes are. Now, there's a couple of changes. One has already come in, as you can see, which is the April 2026. This is that the disclosure of a sexual harassment became a qualifying disclosure for whistleblowing purposes. So that's to add to your list of breach of a legal duty, health and safety breaches. And I don't think on the ground this actually changes very much, because obviously if someone reported sexual harassment, you wouldn't subject them to a detriment anyway, you would hope.
It was already a legal obligation.
And it was already a legal obligation. So I don't think there's going to be very many changes for practical processes. It's just sort of another avenue of claim that people might have. And then October 2026, we've got the big changes coming in. So firstly, there is an amendment coming that it will become a mandatory duty to take all reasonable steps to prevent sexual harassment. Since October 2024, you've already had a duty to take reasonable steps to prevent sexual harassment. The change is that wording of all reasonable steps. It is quite a broad change, and it probably is going to impact a lot of workplaces and what that means in practice. And then the second part of the change is this, the protection is going to be extended to third-party harassment. And that, very importantly, is not just sexual harassment. You're going to have a requirement to take all reasonable steps to prevent any harassment by third parties. I'm sure you're all aware what would be covered by third parties, but we're talking about any clients, customers, contractors that come on site, anyone who's interacting with your employees and workers during the course of their employment. We don't yet have a definition for what all reasonable steps mean, or reasonable steps in any event, and that's not coming until 2027. So you're going to have this duty before we actually have any kind of definition of what reasonable steps is, which is tricky. I think.
Sensible approach.
Yeah. So there needs to be a little bit of thought behind the scenes for your business on what the risks are and what reasonable steps could be. And then the last change to flag in this area is that there are going to be limits on confidentiality clauses, or NDAs. So almost all of you will have these in your settlement agreement templates already. And the proposal is that any attempts to limit employees talking about harassment or discrimination will be automatically void. So you're going to need to take that out. Now, I think that a lot of confidentiality clauses are probably too broad at the moment anyway to be properly enforceable. So it's quite a good time to start reviewing those in any event to make sure that they're no broader than they need to be and not unreasonably restrictive.
Yeah, this may give us guidance on what they think should be included in that, so you can take a look at.
Yeah, absolutely. So a few tips in this area. Firstly, every business's risks is going to be different. If you are in retail, your business risks can be very, very different to if you're an office-based role, for example. And within that, the different areas of your business are probably going to have different risks. So to go back to retail, if you've got a shop compared to a warehouse, those are probably going to have some quite different risks depending on the kind of people that are going to be coming in and out, and particularly for your third-party risks, I should say. So we're really recommending that employers carry out risk assessments now for the different areas of their business, and think really carefully about your specific areas of risk. So for third parties, where do your employees interact with other third parties? Is it customers coming into the store? If you're office-based, have you got communal lifts or lobby, for example, that they're going to interact with other people from other businesses? Those are where your risk areas and where you really want to consider. And then you're going to want to think about, okay, so what reasonable steps could be taken? What could you do to prevent that harassment? And then for your business, what is actually reasonable? What can you actually do of those steps? And I think it really needs to be that staged approach to reviewing what's reasonable. And obviously, you can come for guidance. We can talk you through your risk assessment and for your specific case, what you can do, because there are only going to be so many things that you can reasonably do. One of the really big ones, just to come back to it again, is going to be training. You can obviously do as much. You can update your policies as much as you like, and we really recommend that you do if you haven't done already. You can put up signage and security cameras, for example, but especially your internal risks, it really needs to be training, and the training needs to be interactive. It needs to be more than just sit someone down and make them watch a 5-minute video. So we would really recommend, especially for management, but probably for all staff, that you have some kind of slightly more formalized training, and make sure you keep that training up to date. So it's a little bit more than, we trained this person 3 years ago, that will be fine. That will make your defense very difficult when it comes to it, if it comes to it. Hopefully it won't. And then obviously review your settlement agreement templates and check the wording of that. I think that's most of the tips that we've got for harassment. But if you want a bit more of a sort of tailored approach, it's as I say, it's different for every business, so it's worth just having a discussion, I think.
Difficult to cover on a broad webinar, but yes, I think all businesses should be looking at bespoke plans if you need help with that. But the risk assessment needs to be up to date and live, and now is a good time to review it if you haven't looked at it for 2 or 3 years since it originally came in. And I think this is the last topic before we go to any questions. So I've got 0 hours and low hour contracts, which is very timely because there is a live consultation on this now. And I was actually in Geneva with an employee of the Confederation of Business Industry when the consultation was launched, and so he was giving me some intel on where we think we might land. So you've got the benefit of that in these slides, happily. So on the key changes and what they might be, we just go to the next slide. Sorry, I know you're looking at the questions at the same time. So this is due in 2027. We're waiting for the exact date, like we are with the others, and the consultation is live. That was launched 2 weeks ago now. So what that consultation is everything under this scope, really. So what 0 hours and no hours is, we need a definition of that, what the notice periods and things like that will be, and how the compensation regime will work. So the changes are going to be massive, and I know this is worrying a lot of businesses that rely on casual staff because you have seasonal highs and lows, or for any other legitimate reason. So I do some support for care teams, for example, and those quite often want 0 or casual contracts because they have more than one client that they work for. Sometimes they'll have more availability during term time or school holidays, and so it works for them. This legislation doesn't really account for those different circumstances. It's certainly a one-size-fits-all approach, and so I think you're all going to have to get to grips with this to some extent. The change is that an employee or a casual worker, will have the right to guaranteed hours based on a defined reference period. That is something that's subject to consultation, and I'll give you my view on where I think we'll land based on my intel in the next slide. So that means that essentially, if they are working over whatever is in their contract on average during that reference period, you as the employer or the business that's engaging them, if they're a casual worker, will have the right to be offered a contract on that higher number of hours. So if they're on a 0 hours contract and they're regularly working 5 hours a week over that reference period, you have to offer them a contract for 5 hours a week, even if they were busy because it was Christmas and they're not going to be needed in a week's time. And likewise, that is an ongoing duty. So after the initial reference period, you'll have to look at the next reference period, and you'll have to do the same calculation for every time and offer them a contract every time it increases. The worker has no obligation to accept the offer that's made. They can say no, and they can say no repeatedly. And then we get into this position where you're going to have to arbitrarily keep offering them a contract that you know they're going to turn down, unless we get any shift on that as a result of the consultation. We do now expect, we've had it confirmed, that the initial reference period and the subsequent reference periods are very likely to be different, with the subsequent reference periods being longer. And the feeling that I got was that the initial reference period may be a short 12-week period, which will make the unions quite happy. And then the subsequent reference period is likely to be a year, in line with the reference periods we have currently, which will make the employers happy. So I think the government are trying to please both groups of people with that, but we'll see where we end up. On top of that, workers under 0 and low hours contracts will have the right to reasonable notice of their shifts. Consultation covers what reasonable notice will be. And they have the right to fixed compensation every time a shift is cancelled or changed. And again, the consultation is covering off where we think that compensation should land and what short-term cancellation looks like. So my view would be, if you are in a sector, if your business relies on casual staff, low hours work, agency workers, absolutely fill this consultation in, because you know the trade unions are going to be lobbying for their members too that are impacted. So fill the consultation in, answer the questions. They're essentially like tick boxes. So it's a, what do you think low hours should be? And then there are options. So put in what you think would work for your business. And obviously we want the reference period as long as possible to deal with those seasonal fluctuations and make sure your voice is heard. I mean, the last bullet point on this slide, I think, is very unlikely to ever happen in practice. You can disapply all of those rules through a collective agreement with the union, but I don't see a world in which the union would be happy to disapply those protections ever. And then, as it says in the big red box, these changes apply to agency workers. So you could end up in a situation where you are having to offer a contract to someone that you don't directly employ. And then you could also be on the hook for a poaching fee to the agency because you've had to offer them a contract and they've accepted it. So I think that something you need to look at is your commercial terms with the agencies. The agencies are obviously aware this change is coming in, to see if you can carve out an exception for that situation, because it's completely beyond your control. One of the caveats, though, is that you would now be offered to, when you offer the agency worker a contract, you can offer that contract on your standard directly employed hourly rate, rather than having to honour their higher agency worker rate, because it normally is higher when they're engaged for an agency. And then in terms of top tips, other than fill out the consultation, please, but yeah, assess what you're using casual staff for, assess your use of agency workers, audit those terms to work out who may be caught. And remember, it is low hours as well. It's not just your 0 hours contract, and we're still waiting to see what that will be. Consider updating the contracts proactively. So if you know that someone is always working and that's not likely to change, higher number of hours than their contract says, just update their contracts that it reflects the reality. Sometimes that does happen. Someone will come in on 10 hours and then actually in practice they always work 20, and that works for everyone. Just make sure the contract's accurate, and then you don't need to do this repeated offering of the contracts every period. Flagged already, absolutely look at your terms with your agencies, penalty fees, transfer fees, what is an assignment length, and the obligation to communicate those changes, because what you'll need to clarify between yourself as the employer and the agency is who is going to be liable if changes aren't communicated, and then there's the compensation penalty. You can look at fixed term contracts to avoid this, and limited term contracts. Of course, there is there if they're workers, and a fixed term contract would make them an employee is the unfair dismissal change if it's 6 months or more. And then yes, you could look at an opt out for a collective agreement, but please let me know if you managed to agree that with the union, and we'll use that as a base for everyone else. And then the points that are uncertain are the ones currently going through the consultation. And I put in my view based on this intel I got from someone I was speaking to a couple of weeks ago. So we think that this initial reference period is going to be 12 weeks, but the consultation gives options. We obviously representing employers want the reference period to be as long as possible. So 12 weeks would not be good if that was every reference period, but I don't think it's fatal if that's the initial reference period, and then we grow out from there, especially if that initial period starts in January. So hopefully just after most businesses' Christmas rush, if that is when they look at an increase. What counts as low hours? There are lots of options in the consultation, but the government has alluded to somewhere between 8 and 20. In my view, 8 is very different to 20. I think 20 is just a part-time worker, right? I don't think that's a particularly vulnerable 0 hours worker, which is what this is aimed at covering. If you're working 20 hours on a contract, that's probably because you've asked for it rather than because it's been forced on you. So we'll wait to see. We obviously want it as close to 8 as possible. How long an offer needs to remain open for? It's going to be no less than a week, but we don't have any more detail on that. And then what counts as reasonable notice? The consultation says 1 to 4 weeks or other. Those are your 2 options. So we think it's probably going to be somewhere between 1 to 4 weeks, but we'll wait to see. And again, for 0 hours workers, I think that's really difficult. If you've got a 0 hours worker giving 4 weeks notice, that's essentially a whole rota if you do monthly rotas. So I'm not sure that's going to work in practice, but we'll wait to see. We do expect a shorter notice period for agency staff, and we anticipate that's going to be 5 days. And there's going to be an exemption where those agency staff are looking at care for vulnerable individuals, which is something that I do work on. So that's really important because that happens last minute. So, for example, if they were to go into hospital, there's no way you could give 4 weeks notice of that, or even 5 days notice of that. And so it's good that they acknowledge that that is a different situation. The penalties and compensation payable and how it's calculated is something else that's in the consultation. What we do now know is that we expect it to be a higher percentage where it's very short-term cancellation, and a lower percentage where it's a longer period of notice. And we think that's going to be a percentage of the expected earnings for that shift, essentially. So they get a portion of what they would have earned if you've unreasonably cancelled it without sufficient notice. So I think your processes around that are going to need to be much better. And again, it's sector specific. And I know things have moved on, but I remember when I was working in pubs when I was a student, and I'd get a text message to let me know if I was on shift that day. And so that isn't going to work anymore. It's going to need to be much more structured.
Okay. So we have had some questions come in, if you bear with me. So the first one, which is from Sinead, is what is the advice for best practice of FTCs which are due to end with over 6 months service, either ending earlier than the original term or at the end of the term? Would a meeting to discuss any possible other opportunities like in redundancy be sufficient, or would an appeal process be encouraged?
I don't know if I'd encourage an appeal process necessarily. That's a good question. But yes, I think fixed term contracts are a dismissal. They've always been a dismissal. So the only thing that's changing is the risk profile. So previously with fixed term contracts, they've almost always been less than 2 years. And therefore we haven't had to worry about the unfair dismissal risk. Now, because if it's longer than 6 months, it will be a dismissal, and you do have the unfair dismissal risk. Yes, you will have to identify your potentially fair reason, and you will need to look at some form of process. My view is it will normally be a some other substantial reason dismissal. That's useful because there's no statutory process or recommended ACAS guide for a some other substantial reason dismissal. That would be on the basis that your reason would be the job you're employed to do, the project you're employed to cover, the maternity that you're covering. That work has stopped now. The project has ended as it was expected to. So we're going to dismiss you for that. It's not deemed a redundancy if they were employed for a specific piece of work. And so there'd be no obligation. They wouldn't be entitled to redundancy pay less than 2 years anyway, but you wouldn't need to follow a full consultation process because it wouldn't generally be seen as a redundancy. So my view is a meeting where you say, as you know, your contract's due to end on X date. That is going to happen. We haven't been able to redeploy you. And then a simple letter to confirm that is all I think you need in most cases.
Yeah, I'd agree.
And I don't know how I feel about an appeal. What do you think on an appeal for that? I don't think it would be strictly necessary, but no. I suppose if you wanted a belt and braces sort of best practice, but I'm not sure what the grounds of appeal would be. Yeah, if it's the contract's ended because that's the end date. I think you would need an appeal if it's not for some substantial reason. So if you're looking at another potentially fair reason, then I'd offer it.
Or perhaps if you're proposing to bring it forward from the fixed end date.
Yes. Yeah.
Then I would consider that.
Yeah.
Okay, so we've got, this is, Hamit has asked, is the menopause action plan part of the GPG, so gender pay gap reporting? So yes, it is part and parcel. You do I understand that you do one action plan that includes both menopause and gender pay gap. actions. And I should say that I'm pretty sure you can do as many actions as you like, but you have to do a minimum of 2.
Yeah, I think it makes sense to do the minimum to start with, and then you've got something to work on. And it's the same portal that's used at the moment, isn't it? It's all on the same website.
So Daisy has asked, if a flexible working request is declined because it's not feasible at the time, can an identical request from another employee be approved later if the business circumstances have changed, with each request being assessed on the circumstances at the time?
Yes. Yeah, very quick answer to that one. Yes. I mean, obviously, expanding on that slightly, if the other employee that didn't get their flexible work request is still employed, I think you'd need to expect some questions from them. And so going back to what we were talking about on the slide, you just need to make sure that you've got a very clear explanation, and you can basically rely on what the question said, that the circumstances are different now. I would then expect a new request from that person as well. And then if they're turned down again, it could be a bit tricky from a labour relations perspective, but legally I'm comfortable with it.
So Sandra's asked, with the equality reporting, is the 250 employees per company or cumulative across the group of subsidiary companies?
Trust Sam to ask a difficult question. I can't remember actually. Some of them are groups, some of them are individual. Do you know?
I don't know off the top of my head, so we'll come back to you on that one.
I'll drop you an email, Sam. Thank you.
Okay, so Colin has asked, does the fire and rehire restrictions apply to jobs that are being offshored to another group company?
They could, couldn't they?
They could, because it would go into the consultants.
Yeah, so you would be directly employing, so it wouldn't be the automatically unfair, as in another group company, it would be directly employing. See, in theory, yes, but I'm not sure that's something the government have thought about.
No.
So would it be an automatically unfair dismissal? I know that there's a carve out for 2P. So I think if you're offshoring identical jobs and it would be a 2P transfer, that wouldn't count unless they've changed on that. Certainly the last time I looked at it, 2P was excluded. So I think if you're offshoring, 2P would normally apply, and that might be your get out. So you might be in a bizarre situation where businesses have always tried to avoid 2P applying in the past, and now they want it to apply so that they can actually do what they want to do.
Yeah, possibly. Okay, so Donna has asked, for harassment, appreciate that this is for contractors associated with the business, third parties. How does working from a serviced office affect this change?
Exactly the same rules.
Yeah.
So yeah, I think that would be a risk that you would highlight in your plan, and then work out how you can manage that. So whether or not it's your office space or a serviced office space, or if you're, a marketing team and you're at a third party space doing an event, if it's in the course of their employment, the rules apply in exactly the same way. Obviously, what reasonable steps you can take to mitigate that when it's not a direct space you control is something you need to think about, but that would need to go on your risk assessment as a high risk, and then work out what you can do to mitigate it. I mean, of course, one step is that you don't have serviced offices, and then you need to work back from there to decide if that's reasonable, and if not, why not. So I think you'd be expected to flag that and deal with it.
And it would probably be a conversation with the office managers about how they're dealing with the risk as well. And then
because they have the obligation to.
Yeah. And then our last question from Anna Maria is, for the 0 hour reference period, would 1 year worked, would you work out the average number of hours worked and what happens with the Christmas period? The second season is lower.
Yeah, so that's why we want a long notice period. So we want a 1 year reference period so that you can capture that. And yes, that's exactly right. So it's the same as if you're calculating holiday or irregular hours. So you'd essentially add up all the hours they worked over that year, divide it by the number of hours they worked in, and that gives you your average number for the purposes of what their guaranteed offer needs to be. And so the hope is that that would help you level out any seasonal flux, because if you only look at, say it's retail and you hire loads of temps for Christmas, if you only look at November and December and average out the hours over those 2 months, it's going to be much higher than if you look at the full year, if they generally only work 2 or 3 hours a week. It still may be higher than you want to offer, but it won't be as drastic as it would be if you had to do it every 8 or 12 weeks.
I think we're probably out of time for any more questions. So if anyone does have any more questions, our email addresses are on the slides. Feel free to ping them over, and we can do our best to answer those with the sometimes limited information we have at the moment.
And thank you everyone for joining, and enjoy the rest of your days.
Thank you.